But that doesn't
are aware
excuse you
of
from violating the conditions.
Your Honor,
Are you justifying that because of that you can just?
The SCRAM device picked up a peak THC of 0.078%.
Say it again.
He also tested positive for marijuana as well.
well, Your Honor,
Those 18 seconds you just watched, that was Judge David Fleischer reaching his absolute breaking point. But what led to that explosive say that again moment is a masterclass in how to throw away a final second chance. This is Mr. Kabir versus the state. It looks like a simple bond hearing, but it's really a high-stakes gamble with his freedom. Kabir was ordered to stay sober, yet a SCRAM device reported a massive .078 reading, nearly the legal limit. His defense desperately argues that he wasn't actually driving. But does that really matter when your own blood is the evidence? Between technical excuses and a surprise positive THC result, Kabir is quickly running out of road. If the judge starts to feel like an enabler, this defendant's freedom is over. To understand the legal tactics and the courtroom psychology most people miss, hit subscribe and watch how this trap was set. Let's see how this unfolded from the very first minute.
State, does he have a DWI open elsewhere to refresh my memory, please? Mr. Salinas, did he not have a DWI?
he currently, yes, Your Honor,
He has an open DWI where?
in Navarro County.
And so we put conditions on him. I can't. Please, Felicia,
The most recent ones, Judge, or there's been a few that we've amended over time.
what are the current conditions now?
The current conditions now are appear in court every time the case is set on docket, no new law violations, install a IID device in the vehicle, no driving without permission of the court, no drugs, no alcohol, plan to obtain a SCRAM device, and to submit to drug and alcohol testing at the court's discretion.
Did he have a curfew as well?
No, Judge.
He originally had a curfew, Your Honor, but because there were no issues with that, we had it removed.
Okay.
Yes.
And so now our first bond violation report that we had was September 23rd, 2024. And in that one, he had been in lockout for failure, I guess, to pay. I don't know, which is weird because we normally always pay for all of them. A second bond violation report was filed January 6th, 2025. Where I guess he was in lockout again because due to no recalibration of the device. And we now, February 4th, 2025, have a third bond violation. And in this violation, the defendant was ordered to obtain a SCRAM device and to refrain from alcohol consumption and not tampering with the device. The defendant's SCRAM device has reported one consumption event that occurred on January 16th of 2025 at 11:55 p.m. It was also confirmed by a SCRAM analyst as well. Correct?
Yes, Judge.
Okay. So,
Yes, Your Honor. So,
Yes.
yes. So to begin with the first amended order for pretrial, so if the state wants a copy, I have a copy to show them, but sure. So, Your Honor, just going to the very first order, as Your Honor just noted, usually agency fees are waived for that. However, the box on that for saying that the fees are waived, I believe, were not checked on that. Further, Your Honor, the main purpose here for your determination of giving someone bond in the first place is to establish that they come back to court. So are they a flight risk? And then also, are they a dangerous community? Now, Your Honor, if an interlock device is in lockout on a vehicle, it doesn't start. No one's driving that vehicle specifically. There's no way that they can. I can call a witness to testify that, but I know that you
but that doesn't
are aware of
excuse you
that.
from violating the conditions.
Your Honor,
Are you justifying that because of that you can just?
No, Your Honor, I'm trying to contextualize this because we've been here two prior settings before. I know you're concerned greatly about the number that it's at number 3 now. I'm trying to establish that the first and second there was no indication of alcohol consumption or drug use during that time.
It wasn't working. How are we supposed to know?
And Your Honor, one of the two main points of determining what kind of bond, both the conditions and amount are, will they return to court and community safety? Here, my client, who's being accused of DWI, wasn't driving that vehicle. So it was impossible for him to be driving that vehicle, Your Honor. So I ask you to take that into account as far as public safety goes. As far as this latest bond violation, it's the state's burden to prove that my client violated his bond. All we have right now is a report by SCRAM, but no one is here to testify on behalf of. Well, we can call that, Your Honor, but
Yeah.
sure.
Judge, I spoke with the defense counsel today, and he said that he was not requesting to have anybody come here to testify to the SCRAM device.
We have Fleischer that can be called up as a witness to testify as to what happened with and whether he tested positive or not, whether he's consuming alcohol.
It's also the state's burden to prove that he did that. So that's, yeah.
Please.
Yes, Your Honor, we would call retrial services, Ms. Felicia Charles.
Okay, ma'am, would you please come up, raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay,
So you have first amended order, and then second, third amended retrial supervisions, and then the fourth. So referencing the fourth amended order for pretrial supervision and bond conditions, what I'm showing you, do you recognize this? Yes. Can you tell us what this is and what are the conditions that are checked?
These are,
Sorry, could you repeat what you just said?
sorry, I said I don't know if she needs that. It was an extra paper.
Okay, I just want it on the record.
Sorry.
Thank you. That's all right.
Yes, these are pretrial bond conditions, and these are listed as appear in court every time the case is set on docket unless the judge waives appearance. No new law violations, install ignition interlock within the vehicle, no driving without permission of the court, no drugs, no alcohol, and then to obtain, we do have a curfew of 9 p.m. to 6 a.m. and then a SCRAM device to be installed.
And so what we're showing you is what's been marked as State's Exhibit 1, and we'll tender this to defense for any objections.
No objections.
admitted as one.
So in this case regarding the SCRAM device, can you tell us about that?
Yes, so what exactly about?
What is that? What's the standard procedure someone's supposed to do?
Yeah, so a SCRAM device is ordered and it tracks the press.
Objection, Your Honor. The foundation, I believe the state is trying to ask her to testify as far as her, are you trying to establish her as like an expert on SCRAM?
And I was not trying to establish her as an expert, just from her experience, what the SCRAM device is basically for, which she can testify to as a trial.
I'd ask that the court consider that as that testimony as a layperson, not as for the purposes of establishing expertise.
So I want to know whether there is a violation for alcohol consumption. So, what day do we have any kind of hot blows? What's the amount? Do you have anything of that nature?
Yes, so the report should have been provided to the bond violation email as well of the graph.
And I'm showing her now what's marked as State's.
For the exact amounts and everything, I would need to look at the report that was provided in the email.
Okay,
Within that.
please.
Have the graphs been printed, State, or she's just referring? Yeah, just so we can all agree on what she's referring to.
And now I'm showing you what we marked as State's Exhibit 6. Can you please tell us what this is?
So this is a SCRAM report sent back to us whenever the device information and data is pulled. And this is what the analysts observe for either tampers or consumption. And this is what they send us back if there is a confirmed tamper or consumption as per.
Okay, so this fairly accurately depicts a SCRAM report and how it exists.
Yes.
We will tender the defense for any objections and note that is it correct to say this has been emailed to defense prior to this date?
Yes.
Defense received it, no objection, Your Honor.
Okay, it'll be admitted.
Okay, so can you tell us about the specific dates in this report again that was given to defense prior to today of the basic dates that the SCRAM was not completed properly?
Yes, so the device seems to be fully functioning. And on January 17th, Friday, January 17th, the SCRAM device picked up a peak TAC of 0.078%. And then established a zero baseline once again for the dissipation rates of the alcohol at 9:05 a.m. on January 17th.
Say it again.
9:05 a.m. January 17th, 0% TAC was reestablished for the dissipation of alcohol.
Okay, and for those dates, the ones that match on what I'm showing you as State's Exhibit 2, the bond violation report, can you please, do you recognize this?
Yes.
Can you please read the details of the violations here?
It says the defendant was ordered to obtain a SCRAM device and to refrain from alcohol consumption and not tampering with the device. The defendant's SCRAM device has reported one consumption event. The confirmed alcohol consumption occurred on January 16, 2025 at 11:55 p.m. This information was received on 1/17/2025 and confirmed by a SCRAM analyst.
Thank you. We pass the witness.
Okay.
All right. Good morning. I just want to, if you could turn to, I believe it was the State's Exhibit 3, I think, for the SCRAM non-compliance report, the cover page. Do you see that? Yeah, what she has right there. Oh, is it 6? Okay. Would you stay, since you're close, would you give that to her? Thank you. So just looking at the cover page there, can you read who the agent is on this report?
Justice Turner.
Are you Justice Turner?
No.
Have you consulted with Ms. Turner about this report?
Through the emails, yes, for the bond violation report and the.
What exactly did those conversations include?
The entire.
Sorry, that was a poorly phrased question.
I'm sorry.
No,
I don't understand.
that's my fault. Don't worry about it. My question is, did she consult with you when compiling this report?
Would you be more specific?
Did you help in the assembly of this report?
No.
Okay. Have you ever assisted or aided in the assembly of a SCRAM systems non-compliance report?
No, no one.
No, no one in the department does. Okay. And do you have any sort of, have you ever worked for SCRAM systems?
No.
Have you ever had any special training in SCRAM systems?
Yes.
What is that training?
I actually met with Ronald Grant from Sentinel, the regional representative, about maybe 2 months ago to get an advanced knowledge of this device. This is one of the very few devices that I do have advanced knowledge in, but not expertise.
Sure. And what exactly did this person teach you?
We went
Briefly.
through how to read the graph, kind of how to establish consumption versus a tamper, environmental factors versus consumption, etc.
Okay. So during that training, did you ever actually look at a physical device, the SCRAM device?
No.
So you didn't do any live experiments where, for instance, you put on a SCRAM and then, drank alcohol to see how that works?
No.
No. Okay. And as far as Mr. Kabir's SCRAM device, have you examined it prior to this hearing?
Me personally, no.
Okay. And so is it fair to say that you've been thoroughly trained on the theory of SCRAM device and alcohol detection?
What do you
Is that fair to say? That you're, let me rephrase that. So you don't have any actual technical experience with how the SCRAM device detects alcohol in someone's skin. Is that fair to say?
think?
I don't want you to think. It's a yes or
I
no.
I still don't understand.
I'm trying to understand too.
Do I not understand how a SCRAM device works, or have I not for myself? And
Sure. So, this is pretty, is it fair to say like the science is kind of advanced here? Like when you received your training, did you have the personal opinion that that was advanced science that you were learning about?
I believe so.
Okay. And you don't, so basically it sounds like your training, and correct me if I'm wrong here, your training was mostly so you could be able to make sense of what a report says and not necessarily how the actual device itself works. Is that fair to say?
Partially, yes.
Okay. What's what am I partially wrong about?
Over, yes, reading the graphs, but then also what kind of would entail, what would mess with the device.
Okay.
Essentially, as well with tampers, environmental factors with that, makeup or placing something between the skin, how things are worked around with the device, how people evade from, having the correct reading on the device.
Sure. And so that's, you basically learned that all in theory, right? There were no withdraw that question. So I'm just saying there was no actual, you didn't look at any studies. Did you read any studies when you did this? Okay.
I actually met with him due to another case. I wanted to further understand it. So we examined the report for that.
Well,
and also reviewed some of the peer-reviewed articles.
Well, that's great. I'm glad that you want to, a lot of people won't. They'll just kind of do their jobs, right? I'm glad that you want to further knowledge. But, what I'm trying to get at is it's fair to say that knowing how something works in theory and actually examining the actual thing itself, the practicality of it is different, right? Do you agree with that statement?
Yes.
Okay, so without actually having examined in your own personal observation how a SCRAM device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Question asked and answered.
Okay, just let's go.
All right. Just ask the question. I don't know if that was an objection or sustained or overruled.
Let's just move on. I mean, we're here to see, is there a positive blow or not? She's testifying that there was.
Sure. I'm just saying that this, all right, I'll make my argument in closing. I don't have any further questions. Thank you.
Okay, closing. Or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if the SCRAM device has been tampered with? Yes. We get notified of tampers and consumption events. And you get notifications if it's been cut off? Just what's been going on with the SCRAM device? You get those notifications? Yes. Okay, thank you. No further questions.
Matt?
No further questions, Your Honor.
Okay, thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a SCRAM device and to refrain from alcohol consumption and not tampering with the device. The defendant's SCRAM device was reported on one consumption event. This happened on January 16th of this year at 11:55 p.m. And this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated those orders. It was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the SCRAM device is a device that can detect alcohol.
Okay.
Yeah, Your Honor, I agree with State insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just taking into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. But with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say it again.
These devices are used all the time.
Well, their use all the time is irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
Inform you of the positive THC or stuff.
He had a positive THC, right?
Yeah,
Well,
that we sent him earlier this week.
he also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Here this week.
that wasn't. Are we still on the record then? On the okay. Well, I would also want someone to come testify about that, Your Honor. But you know that I'll make. I know, but I know you already made your ruling. But I was ready to testify on that because they don't have anything on chain of custody on the test itself, on whether it tests cannabinoids, which Delta 8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any Delta whatever. Regardless, it's number 3, goes with you. All right, off the record. Sorry. Thank you. But I just can't, with an open DWI and a third, that's it. I can't just keep doing it, you know? At some point, I become an enabler, and I can't do that. I can't keep doing it, you know? So.
Well, I mean, Your Honor, I understand you revoked the bond. Would you consider raising it to?
Well, I am going to raise it, right? I'm going to raise it to 7503 now.
Well, and look, I'll just, if you could take this into account, Your Honor. This is a hired client. You know, he has every intention of taking this case to trial. So I would, you know, just, I'm not cheap, Your Honor. So if you could keep that into consideration on that.
It's, you know, and it's
I understand.
representing him in Navarro too.
No, I'm in touch with his counsel there, but no, I'm not representing him there.
Hey,
Yeah.
But tell him this, that he's lucky that he didn't revoke him on the first 2 cases, considering that he has an open, you know, really, because, and I'm telling you now, I don't know how I didn't, but I can't just keep doing it. I can't.
75.
7503.
Judge Fleischer made the call. Mr. Kabir is back in custody with a $75,000 bond. But here's the question. Did the defense have a point? Was a technical expert required to prove the science behind that blow? Comment below, Team Kabir or Team Fleischer. Was this justice or an enabler finally saying enough? If this clash got you thinking, hit like. Share this with anyone who loves watching the legal system in action.